All right, if everyone could come back from break, that would be very helpful. Tom, if you could, there we go. Senator Skinner, Judge Espinoza. Dean Richardson. Great.
Sorry.
All right, let's just wait for Senator Skinner. If you could join us, that would be great. I'll give her one more minute and then we'll get started. All right, let me give a brief overview about how exactly we're going to proceed. I'm going to say a few opening comments. The way that I thought would be the easiest and best way to vote on these proposals would be to share my screen. Many of the slides that you'll see will be very familiar, in fact, almost identical to what we've seen before in terms of the ideas. And then there'll be a second screen with specific details and decisions that each one for us to make on each proposal. My hope is that we will have consensus on certain number of the bullet points of decision points on that second screen. And once a consensus is reached on those bullets, whether it's all of them or some modification of them, then we will vote as a committee to adopt that as a recommendation. These will be the formal recommendations of the committee. The staff will then draft a report in support of those recommendations that may fill in some details, data, and analysis from other states to help legislators and the governor as they work to implement those proposals. Some of the proposals are quite specific, and some of them leave more room for the legislature to make their own decision. And of course, we can decide how specific or general we want to be along the way. Yes, Assemblymember Kamlager.
So is it a straight up and down yes or no? Is it a sliding scale? Are we ranking?
The way that I would propose that we go forward is that for each proposal, it's a yes or no. You'll see there'll be nested decisions. General, most general, do we agree? Yes. A little bit more detail, do we agree? Yes. A little bit more detail, do we agree? Yes. A little bit more detail, maybe not. Okay, so then we will agree on the most general, on the most specific that we can all agree on as a formal recommendation. The rest will be left to be filled in by committee staff, not that they are making recommendations on behalf of the committee, but that they are explaining the background, providing alternatives, showing what's going on in other states to help fill that in. I think it'll become self-explanatory. And if there are additional details that we want to add along the way in the course of this conversation, of course, this is our chance. And likewise, if there are details that we want to scrap or we do not agree with, we will cross those out. Okay? With that said, as you know, we've spent most of the past year, which is the inaugural year of the committee, reviewing the penal code, and as directed by the governor and legislature, we paid close attention to criminal punishments in particular. We heard from over 60 witnesses, including Governors Newsom and Brown, the Attorney General, and other members of the administration. We heard from crime victims and victims' rights organization, including the president of Crime Victims United, elected district attorneys, the then president of the District Attorney Association, and other members of law enforcement, including representatives from CCPOA, the Prison Guards Union. We've also heard from activists, advocates, people directly impacted by the criminal justice system, and thanks to cooperation from prison authorities, we even heard live testimony from a current CDCR inmate. In addition to our live witnesses, committee staff and I have had dozens of conversation with other stakeholders who have been incredibly helpful, including members of the governor's administration, outside advocacy and resource organizations, leaders from other states, and individual members of the community. Also, I have to note, none of this work would be possible without an incredible amount of time and effort from not only our committee members, but our spectacular staff who did most of the heavy lifting on this work. We attempted to find common sense solutions to problems where the penal code was ineffective, unfair, or unclear. I think we gravitated toward revisions where we sensed general consensus. And we're glad to find, or I'm glad to find, that for the most part, there's widespread agreement on the revisions that we've been considering. With regard to criminal punishment, we are guided by the principle of reducing unnecessary incarceration while improving public safety. And I think that our proposals are supported by the data on this. For practical reasons, and to provide some limit to our broad mandate, we intentionally avoided areas of law that could only be revised by a 2/3 vote of the legislature or by ballot measure. In total, we've distilled our conversations over the past 10 months into 10 recommendations, which is taken as a whole would affect almost every person incarcerated in jail or prison in California. We begin with traffic infractions on the one hand and end up with proposed reforms to parole decisions for people serving life sentences. So from infractions to misdemeanors, all the way up to life sentences. None of those proposals we're about to share should be a surprise to anyone. We've discussed them all in open meetings and shared the proposals in our published memos. Today, we will vote on whether the committee should adopt each proposal, and our final report, which will include additional data and analysis, will be approved and published in January. Before I share my screen and get started, does anybody have any questions? Okay, I think I share screen power. All right, can people see?
Yes.
Okay, so as we have before, we have divided our recommendations into 3 categories. The first is short sentences. This is a slide that everybody should have. Hold on one second. Let me see if I could present view. Is that better for everybody? Okay. This is a slide that, so you'll see these slides, the white slides, you've seen before, and we've discussed in previous meetings. I'm continuing our order from our earliest meetings and lowest level punishments, and then we'll end with the higher level punishments. So we discussed reducing punishment for 2 common traffic misdemeanors, driving without a license and driving on a suspended license for failure to pay a fine. And we would reduce those from what are called wobblets to mandatory infractions. The projected outcome is that thousands of misdemeanors for these driving crimes would be reduced to infractions, and the total of fines and fees would be reduced significantly. Here is our details and decisions page, and I'd like to go through each one. And I'm not going to ask for a formal vote on each one until we get to the bottom, but please raise any thoughts or objection as you have on each one. So the first is to eliminate misdemeanors for driving without a license and for driving on a suspended license for failure to pay a fine or appear in court, and change these to mandatory infractions. Okay, without comment, I'm going to proceed. We will also recommend to reduce fines and fees for these infractions. The current maximum penalty is $4,000. So I would encourage a reduction in those fines and fees. I am not comfortable with recommending what those reductions should be unless people have current thoughts. It's a very complicated matrix about all the different fines and fees, but I think that they should be significantly reduced. Without any thoughts or input, I'm going to say our third recommendation would be to reduce the DMV points that are used for these violations from 2 points to 0 points, which obviously also have financial and other ramifications. That is the recommendation for this particular proposal. Does anybody have any comments or suggestions? All right, then I would move to make this our first recommendation of the committee. Does anybody second that?
Second.
Second. Does anybody oppose this to be a recommendation of the committee for the revision of penal code? All right, it's adopted. Thank you. It's our first one. Congratulations, everyone. 2. This is another conversation. This is all familiar, so I'm going to move with some speed. This is to reduce the number of people who are sent to state prison or CDCR for short prison sentences. We heard testimony that 37% of people who are sentenced to state prison annually for determinate sentences are there for less than 1 year. This proposal would require counties to maintain custody of those folks. It would also provide that people who are serving long jail sentences, 5 years or more, they would go to CDCR instead, and the state would financially compensate the counties to cover additional costs. And our projected outcome is that this would increase incarceration in county jails and reduce the overall prison population. Here are the details and decisions. Number 1, require counties to maintain custody of people who would serve less than 1 year in CDCR. As we've discussed, we chose the 1 year somewhat arbitrarily because that was the data that we were given. And my instinct is to stick with it. If legislators along the way believe that 18 months or 8 months or 2 years is the better number, that's fine. But given the data that we have, I think 1 year makes sense.
I want to clarify, because
Yes.
this is independent of the sentence or the crime. So if my understanding, it is because we know that there are people who are held in county jail, but there could be a long time before trial or before sentencing. And so ultimately, once they are sentenced, that maybe they were sentenced for, say, 4 years, but all they have the remaining time is, say, 9 months. And so that's the basis of this recommendation, right? It's not that you would only stay if you had a sentence of less than 1 year, correct?
That's absolutely correct. By virtue of the fact that it's less than 1 year, it's usually people who don't have 10-year sentences because you haven't spent 9 years in county jail. So for the most part, this is a relatively modest sentence, but correct. It's the amount of time left you have on your sentence after being convicted.
Okay, I just think that's worth it to clarify somewhere in the recommendation.
As long as we are all, for the purposes of today, I hope as long as we are all understand that point, the report will absolutely make that clear. Does anybody not understand that point that Senator Skinner made? Is everybody clear on that?
I would just add one thing, Mike, briefly. I think
yes. I've asked Tom to add a color commentary. So
we said I was going to be the Ed McMahon to Johnny Carson, but we'll see how it goes. I think that's a great point, Senator Skinner. So there could be tremendous county diversity in sort of who this affects. There are some counties that are fast, some counties that are slow, and you're right. So there will be people who sort of have the same sentence, same offense, who sort of would end up in a different place. And I think that's an important sort of unknown, uncontrollable part of this, but I think it's a really important one to think about.
Just a quick clarification. Does this take into account any good time, work time credits? Is it
yes,
actual 1 year?
This would be actual time.
Actual
correct.
time.
Would,
okay.
Yes.
Length of stay, expected length of stay.
Okay.
This is Espinosa again. I just want to remind the other members of the committee that I expressed some concern about the work that's going on in Los Angeles County regarding work that my department is leading in an effort to close Men's Central Jail. And part of that effort is our goal to reduce the current population by at least 4,000 persons. So I'm going to support this recommendation, but I just wanted to remind the committee that there will be some well-placed pushback on this for reasons that are not just based on budget.
Yes, I appreciate that. I'll say a couple things about jail population. We received yesterday information that jail population, mainly as a result of COVID, is significantly down statewide. We hope to keep, I hope that is some way manageable. Other proposals that we have are targeted at reducing the jail population. We could consider saying that they should be tied. In other words, only accept this proposal if you do the others. My recommendation would not to be, but taken as a whole, I don't think that there should be a net increase, significant net increase in jail population.
Yeah,
Now,
I support this recommendation just so
Okay.
that we're clear.
I understand. Point two is that there be some financial compensation to the counties for the additional jail population. Again, I don't want to get into, or I don't have any particular expertise or feeling about how we would financially compensate those, but similar to realignment and also the COVID emergencies, counties are compensated for the additional burden, and I would encourage that.
I want to just speak to that for a minute. I mean, that is our, what we may call our custom and practice. So I think that we should word this a little differently. I think that it should be something like state follows same practice if county jail population increases as a result. Because
Got it.
I just think that we don't really, I don't mean in all to underestimate if the counties have an additional burden. Obviously, the state must take some responsibility for it. But I think the way it's articulated may be like, we have to compensate them regardless, and that there's an assumption that it will be an additional jail population when there may not be, right? So that in other words, additional things that we do in this could result in that this recommendation does not increase certain counties' jail population. And the way it's written is an assumption that it will automatically. So I think we just revise the wording so it's more neutral.
So compensate counties for
So that
additional
I think
population
follow
as a result
state
of this
practice.
measure.
Follow state
Okay.
practice for county compensation if the jail population increases.
All right, I want to pause here for a technical issue. Tom and I have discussed about trying to edit this live. Tom, this is our first chance. If this works, this will be great. If it becomes too clunky and too burdensome, Tom, can you incorporate Senator Skinner's suggestion for number 2?
Absolutely. This is like watching like a live rocket launch or something. So, you know, it could all crash on us, but we'll give it a shot. We're going to have that kind of issue.
You want a countdown, Tom? Like a rocket launch?
Definitely not. That would guarantee your problem.
Well, we could, I mean, one suggestion is we could adopt, and then towards the end, Tom could show us the revised language versus trying to slow us down right now.
I just updated it, Mike. So I'm
With I guess because my screen share situation.
I don't know.
Yeah,
All
I
right.
think it could really, this could slow us down and we could just look
Right.
at the language.
I agree.
Yeah.
So let's all mentally, I agree with Senator Skinner's to current practice of compensating jails for burdens directly related to this measure. More specific for number 2. For number 3, transfer people who are in jail, who are now serving long jail sentences, to state prison.
I want to raise one issue about that. I don't know how many, so this in effect is touches onto the state's realignment policy and potentially Prop 47. If because 47 also changed some sentencing that would result in a person being in jail versus in prison.
Not for this amount of time.
No, say again?
I don't think you could get a 5-year sentence for Prop 47
Okay,
offense.
well, anyway, I'm not saying that it impacts a 2/3 vote. I'm only saying that there's, I guess I'm not sure that we should, if there may be a realignment policy that results in someone, for example, being in 6 years. And I don't know that, I'm speaking, but I'm just wondering why, if it's like, whatever, 5.5 or 6 years, is this, I'd rather understand better how this may or may not conflict with the existing realignment policy.
So here's my understanding, and we can table it after this, but my understanding is that there are some cases under realignment where people are serving very long sentences but because of realignment, they're forced to serve those in county jail. And we've heard this somewhat anecdotally as being a significant problem. We believe, based on data we've received so far, that the number is relatively limited. Tom, under 100?
No, under, I would probably between 1,500 and 2,000. I had the most
that
recent,
much.
yeah, but for example, as of July 8th in LA County Jail, there was 155 people who were serving more than 5 years. So that's, the biggest jail, obviously.
Right, 155, you said, okay, and serving more than 5 years, was that 10 years or was that 6 years?
There's 25 serving more than 10 years, and the remaining 120 were 5 to 10 years. So it clusters on the lower end as we'd expect with the type of sentences that would be jail.
So
I'm a little uncomfortable with this one, only not yet understanding the data or the implications.
how about this? This is an attempt to give some compromise to the jails and to folks who feel that they're serving, that this is an unanticipated consequence of realignment of people serving very long sentences. Instead of saying, giving a number of 5 years, that our recommendation is that long sentences to be determined by the should be transferred to CDCR.
I think we could say recommend that relook at realignments. If there's a realignment result that is causing jail sentences of higher than X, right? I think that because again, the 10 years, is it due to enhancements? Is it due to, right? So
I mean, part of it is that we don't know if it doesn't matter why they're there. 10 years in county jail that doesn't have proper programming, proper yards, proper facilities to hold people for very long. That's what our concern was.
Yeah, and I think that this one,
Okay. I mean, do other people have insight here?
I don't have a per se opposition to to not having long sentences in county jails. I just don't have enough data for us to have a blanket adoption of this one.
You mean,
or how it would impact, say, our prison population. So
So you're
that's why
saying
number 3,
go ahead, sorry.
I'd either hold it, just remove it from this to be discussed later when we have more data, or have just a recommend to look at.
Other people have thoughts about that?
Yeah, I will say that having been in the county jail and spoken to prisoners during a couple of town halls we did, there, for example, we met a woman who was halfway through a 12-year sentence in the county jail on drug offenses. It's just a horrible place to spend that much time. I mean, you've alluded to the lack of facilities, proper facilities for those long sentences, and I think I don't know what the answer to Senator Skinner's realignment concerns are, but this needs to be addressed, is all I would say.
My proposal was that for number 3, we would say transfer people in jail who have long sentences and leave that vague to CDCR, and that our recommendation is to the legislature to figure out what, and then the analysis that will be provided in the report suggests analysis on how many people of what years, what's the proper cutoff and whatnot, but that the committee recommendation is that this is a problem that should be addressed.
I want to just jump in. The only thing that makes me uncomfortable with that is what Judge Espinosa just said, because there's going to be different interpretations of what a long sentence is. And, you know, some people, go on.
We're not recommending legislation. This is a recommendation to the legislature for them then to decide what a long sentence is.
Right.
Now, the question is, do we want to specify to the legislature that we as a committee find that 5 years is the right number or 10 years is the right number? Or do we tell the legislature, you should go find what the right number is?
Right, which is why I understand all of that, which is why I think putting in a number like 5 is important, because it anchors at least our view at 5, right? Like we might disagree whether it's 5 or 3 or whatever it is, but I think putting a number in like 5 at least gives some sense of what we're thinking versus leaving no number in there. Someone might say, transfer people in jail who have 10 plus years to serve in CDCR. So I like signaling something, I guess is what I'm saying, even though I also understand Senator Skinner's point. So I don't know how to resolve that, but I just feel more comfortable putting in some number to communicate our thought on what might be too long.
I think this warrants more discussion, only that because I completely, more than in principle, agree that people should not serve long sentences in county jail. However, I'm also cognizant of the fact that we are still over capacity in the state prisons. And while there's other things we are doing that may bring down that number, this is alone in it, just in isolation, an increase to that capacity, which is not good right now. And that additionally, there can be, I'm not saying it's totally operative everywhere, but there can be a perverse incentive to the county to potentially increase sentencing or term lengths so that the burden is then on the state versus on the county in terms of cost. So even though there is some compensation under realignment, many of the counties would argue that the state doesn't properly compensate. And so many counties would prefer to have all of their people really in state prisons. So there's many, many layers of implication to this kind of policy, just as in isolation. So I think it might be worth it for us to have to separate it and have a conversation, when we, in our next phase around this particular.
Really good point, Senator Skinner. It's about the perverse incentives, right? I hadn't even thought of that. You're completely right. Thank you for that.
And to that, the truth of the matter is that when realignment passed, there was a lot of charge around decisions and increase in second strike sentencing. So, so the proposal for the time being to get consensus is that we strike number 3 altogether and we save that for another day. Judge Espinosa, how do you feel about that?
Well, while I'm sensitive to Senator Skinner's concerns, when you say another day, do you mean to be included in this year's report or next year's report?
Well, it cannot be included. If we do not agree on it now, it cannot be included in the January report. However, there is the staff analysis that will go along with these recommendations. And the staff analysis could include some of those data points.
Sure.
But it's not a formal recommendation of the committee, but it'll be part of the report saying, and here are some options on how to manage.
Sounds good.
And implement this policy. Is that a fair compromise?
Or we could say, recommend that there be a look at, more than look, that policy be revised to ensure that, or to limit the longer term sentence time in jails, right? So that's a little different than, if you read it this way, it's immediately transferred to CDCR versus look at the policy that results in people spending longer time in county jail. If you get my nuance.
I do, but you would not put a number on it.
Correct. I mean, I appreciate Judge Espinosa's concern that by our not acting on anything, then we're silent on our feeling that people should not spend long times in county jails, which I think we all agree on. It's more, what is the right, you know, if we get down granular, what is the right policy adjustment?
So the policy you're recommending is review rules and regulations that result in people serving longer than 5
years, longer than 5 years in county jail.
Okay. Does that sound good? Review policies and regulations that result in people spending longer than 5 years in county jail. Does that satisfy?
I guess, I'm sorry to have to jump
Go
in
ahead.
again. When we phrase it like that, it sounds like we don't object to people.
Okay, so you can add a qualifier somewhere in there. Add a
Yeah,
qualifier.
something that makes it clear that we think 5 years might be too long. There's so much nuance in what Senator Skinner is saying. It's hard to put it in, because I agree with what you're saying, Senator Skinner. But I also want to send the message, and I think you do too, that if we knew that there weren't these perverse incentives on the other side to sentence people to longer periods of time, if we knew the answers to those questions, we might all agree to the way number 3 is phrased right now. So something in there that makes it clear that we think long sentences should not be in CDCR, including 5 years might be too long. I think it's too long. So we just need to review this is not the language we're going to use. I'm just trying to explain why I want to add something to the suggested language to communicate that we're not agreeing that 5 years is short, but I don't know how to do that. So
We have to find something that we can agree to vote upon
yes.
right now, so we're all on the same page. Tom, do you have language based on what we've just all talked about?
I have two thoughts that might help. The first, I think with the sentence length, the credits issue is really important here, because everyone who's doing and I'm Rick or anyone jump in if I'm wrong, anyone who's doing a jail sentence is likely to be getting 50% credit. So when we talk about 10 years, it's more like 5 years. 5 years is more like 2.5 years. Of course, that assumes that all works. So it complicates a little bit more.
Yes, so this is, again, we're talking about time served. This is not the length of sentence. This is the estimated time served, not.
Okay. So then those numbers I gave you about the 125 or 155 people are about the sentence length. So it might be even less people when we get to actual length of sentence. So it might be less than 1,000 if that's the case. That's just an idea. And one way to address the perverse incentives might be to make this something that the incarcerated person can have some control over. I mean, that might make it a hard sell, but that would be might solve some of these concerns as well. I don't know if we want to get too far into that.
I actually don't think that solves the problem, because it's all a matter of plea agreements. So Tom, but we need language that we can agree upon right now.
What about limit policies and regulations that result in people spending longer than 5 years in county jail? Does limit do some helpful work for us?
Revise policies and practices so that time served in county jail does not exceed 5 years.
Love it.
Got it. Agreed.
Like it.
Great.
Judge Espinosa?
I guess you want me to unmute. I was giving you a thumbs up. Yes, that sounds
Oh, I'm
good.
sorry. Just the way that
That's
my
okay.
screen works is hard to see everybody. Okay.
It's okay.
So good. Thank you. Moving on to number 4. This addresses some of the concerns about the jail population, Judge Espinosa, that you even raised, that we would add provisions to help manage the jail population. Right now, it's difficult in some circumstances for jails to transfer between each other. So if one neighboring county has excess capacity and one county is over capacity, In many circumstances, current statute prevents jails from transferring prisoners. Now, obviously, in times of COVID, let's put that aside about the wisdom of transferring, but we would eliminate that. We're recommending to eliminate that restriction so that counties can negotiate within each other to help manage their population. Subpoint 2, the penal code currently includes a provision that all county jails are supposed to have a parole release process like BPH that we'll be discussing later on, where they're supposed to review people for their ability to be released based on threat to public safety. We think only one county currently has one of these parole release mechanisms. Is that right, Tom?
I'd love to be wrong about it, but the only one I know for sure is Kern County.
So we would like to find a way to increase those parole release processes. So that gives sheriffs, it's already existing in law, sheriffs to convene parole authorities to review people for safety to be released from custody. That's already in the penal code. There's some way to encourage that. Another, this is subpoint 3. We heard a lot of feedback that as a result, another negative consequence of realignment or unintended consequence of realignment is that there's a difficult, what they call warm handoff between jail authorities and the post-release supervision, whether that's state parole or county probation. And so we would like to revise the rules to make sure that those handoffs work as intended. Any comments on number 4?
This may be a little far afield, but it would seem to me that we might want to put in something that would allow for prisoner consent before they're transferred from one county to another. It impacts their ability to, visit family, etc. I don't know.
Okay, so here's the, I think that that's not a bad idea. The question is, should that something like that be the full board recommendation, or should that be part of the implementing analysis that's in the committee report? If the full board agrees that everybody thinks that that's an essential part of the transfer piece, then it should be part of the full board recommendation. If we're unsure about it, then it can be part of the analysis.
Well, given that,
Right.
I think that it being part of the analysis is probably sufficient. I just want some acknowledgement that, people may not want to go from one county to another.
Agreed.
I don't know that it has to be in the recommendation.
Some people might prefer it because the other county might have better facilities.
Mhm.
All right. On number 4, any additional comments or thoughts?
So how are we thinking now that we would put this as, explain this a little, because on the
So
one
our
hand,
recommendation, so for number 4, we would recommend permit transfers between county. So that's eliminating a current rule that prohibits transfers between counties in certain circumstances. Increase.
That's another one where I'm not sure. There's implications. There's lots of unintended consequences of this. There's pros, but there's lots of unintended too.
This is an attempt to, all in the attempt to try to help sheriffs manage their jail population, which we are adding a burden on
So
them.
that's the kind of thing that obviously in any negotiations with the counties or the jails, in terms of the sheriffs or the counties, in terms of how our policy practices, these things can be discussed. For us to blanketly recommend it without having any belts or suspenders on that might address the unintended, gives it the, it doesn't convey that there could be these various either unintended consequences or perverse incentives. And so it's so anyway, so I think it's better. I think this is the kind of policy that isn't something we should necessarily be recommending, but what is the outcome that we want? And then as it's negotiated, this might be a result.
Okay, so
I mean,
just to
what
be
are we
clear,
trying
just
to,
to be,
what are we trying to solve?
we are
or-
there is currently a prohibition on counties.
True,
So the only recommendation is to eliminate that prohibition.
but if we're not trying to solve a particular thing, I don't think we should, I think we should be silent on it if we don't understand either what it solves.
Okay, if there's no consensus on eliminating that prohibition. I mean, again, that could be something that could be moved to the committee analysis and say, we could just agree on large bullet point 4. It said, we could say, add tools to help manage population. That's something that we could all agree on.
Right.
And then subpoints 3, all be part of the analysis, the report analysis. I would say, with the exception, I would say the warm handoff piece, I would elevate that to a formal recommendation. That was really stressed by a lot of folks. So the other two I would include in the analysis, but I would specify warm handoff to a full recommendation.
I just want to, and why would we remove, I might have missed this, so I'm so sorry. Why would we remove the second, increased county parole release process? Because we still don't know what the unintended consequences are. Is that right? Is that the reason that we would remove the second sub point?
I'm fine with the increased county parole release process. It's only the first bullet that I had some.
Okay, so good point. All right, so maybe we just move the first point into the analysis. The other two are formal recommendations. If anybody, does anybody have any problems with the parole release process or the warm handoff?
No.
Okay, with Senator Skinner's recommendation to move the transfer between counties to the analysis, we will do that. Moving
Now,
on
does
to
this,
number,
I do have a, will this trigger some sort of budget discussion?
all of this will,
Yeah. So I just need to.
absolutely,
I need
all of it will. I mean, we're going to pay this, this recommends to follow state practice to compensate jails for over, so.
Okay.
All right. The last is perhaps the most complicated, and I don't know if we want to, this is bullet point 5. If people have strong feelings, I don't know if we'll find unanimity here or consensus, but there's 2 ways to go about implementing this type of policy, or 2 broad ways. One is a mandate, meaning sort of like realignment. If it's less than 1 year in state prison, counties do not have a choice. They must keep those people. That I'm going to call a mandate, and that is along the lines of realignment. The other is to develop some sort of financial incentive structure that incentivizes, either by penalizing or by rewarding counties to implement this kind of policy. So if there's consensus on one way or another, whether this should be a mandate or an incentive policy, I'd like to hear people's thoughts.
So this number 5, you're saying it reflects all the above. In other words, should the 4 above be mandatory or encouraged? And I'm like, let's be silent on it, because that again is one of those things where we're making a recommendation. I mean, you're right. There's always the devil in the details in implementation, but in the negotiations around how to implement, since this is something between the state and the counties, that's where it's figured out which things it's best figured out, which things should be mandatory and which things we're gonna get a better result if we just incentivize versus mandate. And in a way, by number 1, we already say require, so that already is a mandate, so we're not even worrying about. And then number 2, we're saying follow state practice, so in effect the others, we don't have to specify yet whether it's a mandate or an incentive, because it's all.
Okay, so that's a good point. So number 1, you would consider a mandate, not
That's
because
required.
you could use number 1 Okay, so how about striking? Does everybody agree to strike number 5 and leave it silent?
I think I think I agree with Senator Skinner, right? I do. I think 1 is a mandate. I think 3, it's already broadened anyway. Yeah, so I agree with that. I don't think it's necessary here.
Okay, with the amendments suggested by Senator Skinner, which
Can I
is
ask
now,
one question, Mike? Sorry to
Yes.
interrupt.
Yeah.
It'd be great to get some guidance from everyone if discussion of incentive versus mandate would be appropriate anywhere in the analysis, or if we should be completely silent. That would be helpful, I think.
I
I
think
guess
that,
what Senator Skinner said about that, as long as it's clear that these are our, and it is, that these are our recommendations, some of which are already mandatory. I think if we put in, you could put in, right, they decide, the way Senator Skinner mentioned, whether it should be which one is the better way to get to the result that we are recommending. And it might be mandatory, and it might be financial incentives, and they know better, they can figure it out, but they know what the end point is that we are recommending. That's how I understand this discussion. And I don't think there's
right, which is why we can be silent on it, because we already have require, which I think we agreed on. So otherwise we don't need 5.
okay.
Thank you.
With those amendments, I move to make this our second recommendation for the committee.
And the amendment of the wording change, there will be a wording change to number 3.
Correct.
I agree.
I agree.
Any opposed? All right, terrific. This is adopted as our second recommendation. Hold on, how do I move to next slide? Next slide. This is another topic that we've talked a bunch about, which is expanding probation eligibility for nonviolent crimes. Currently, certain nonviolent crimes, you're not allowed to get probation. The rules about which crimes you can get probation for and which rules that you can't is all over the place. For example, murder you can get for, but certain nonviolent crimes you cannot get probation for. This would end mandatory minimum. There are mandatory minimums for nonviolent crimes. This does not say that probation is required. It is just allowing judges to give probation in all nonviolent crimes. Let's get to the details. This would permit judges to set appropriate sentences, including probation, for all nonviolent crimes. Should probably read number 2 and number 3 in conjunction with number 1. Now, as you guys know, violent and not violent crimes and serious crimes are terms of art and are listed in the California Penal Code. The proposal as it stands is that it would allow probation for serious crimes which are not violent. A residential burglary where no one is home is not violent, it is serious. And the current proposal would be to allow probation for that offense. Not required, but it will allow it. That means the maximum sentence, I believe, is 5 years in state prison. And in this case, the minimum sentence would be probation, and give that authority to the judge.
I think judges already have that authority, quite frankly.
Tom?
On the burglary one in particular, Judge Espinoza, it's one where there's a presumption against it. One of those,
Right.
It has to be an exceptional case. So this would just sort of remove that and put it on a level playing field.
Yeah, that's a different idea, and I think that's great. Otherwise, I have imposed numerous illegal sentences by putting Resburg folks on probation.
I should have clarified. This would eliminate those presumptions one way or another.
I'm in favor of that.
Yeah.
Okay. Number 3 is there are certain nonviolent sex crimes that, for various reasons that are yet to be explained to me at least, example, rape of an unconscious person is a nonviolent crime. I propose that we exclude that from this proposal. So that means prohibit probation for rape of an unconscious person. However, there are other sex crimes, failing to register as a sex offender, that I would allow that I'm proposing that we allow probation for. So to taken together, permit judges to impose probation for all nonviolent crimes. That includes serious crimes like residential burglary. It does not include certain nonviolent sex crimes, for example, rape of a non-conscious person, but it does permit other nonviolent sex crimes like failing to register as a sex offender. Questions?
And Mike, I would clarify, I think that last category, the only
Yeah.
one there is the failure to register. So
Yeah.
you're just
Okay.
to help clarify.
So,
And so why prohibit probation for that?
no, we're permitting probation for
Permitting
that.
it.
We're prohibiting it.
No,
for
it
rape
says
of an
prohibit probation for nonviolent sex offenses,
Then read the next bullet.
but permit probation for failure to register, right?
So, okay, so I think this is one of these.
Yeah, like I don't know why I
Right.
have a question about 3.
It totally makes sense to prohibit probation for rape of an unconscious person. However, not seeing the entire code of all other nonviolent sex offenses,
Right. Yeah.
I'm like, wait a minute, because they're not all equal. And what we have, unfortunately, there's so much, we experienced this in the legislature just this last session, where there's so much, emotion around the word sex offense that we exclude it all the time from almost everything we do without understanding what the sex offense is. And of course, we now fortunately have changed the registry, but we used to have, if somebody urinated in public, they had to then be on the sex offense registry for their entire lives. And the urination in public could be considered a sex offense. And so would we say that you couldn't have probation for that? So I'm like, I'm not comfortable
Okay.
without seeing the entire list of sex offenses. This seems to fall into that emotional reaction that we get too often around just the term sex offense.
I agree.
So
I agree. And it becomes a catch-all for prosecutors to figure out ways to lump folks into that category.
So a solution that solves this problem is to strike 2 and 3 altogether. Permit judges to set appropriate sentences, including probation, in all nonviolent crimes, period.
I like that.
I do too. I probably like number 2, but I think the word serious gets into, again, it can create the same emotional response as the sex offense term. And yet we know that list of quote unquote serious offenses has huge variance. And so that there's some that everybody would agree, maybe not everybody, but the majority would agree should be probation. But when they see the word serious, they're like, no. And so
that's why I'm striking number 2. Residential burglary is not violent, but we're
already in number 1. Okay.
Yeah. Okay, so strike 2 and 3. Simple. Allow probation. I put 2 and 3 sort of to flag them as just to make sure that we knew the details of what we were voting on. But I think we were all in agreement. Allow probation, does not require probation, no presumption one way or another, but allows probation for all nonviolent crimes. This is another good way to say that we are eliminating mandatory minimums for all nonviolent crimes in California.
So technically, by adopting 1, we in effect we would allow then a judge to permit probation for failure to register as a sex offender.
Correct.
Okay.
And I just to help, very helpful discussion, just to give a little more context. I think it's just a very random list of what serious offenses, what sex offenses have any prohibitions or whatever on them. So I think really the Resberg is the one serious offense that has a prohibition on it. So it's this whole thing that Mike started with, where it's just kind of there's no sort of theory behind it. So I think what this idea does is say, okay, here's the theory. If it's nonviolent, probation is permissible, and then that just resolves a lot of sort of a Swiss cheese approach that's otherwise there. And I think there's a lot of nonviolent sex offenses that are probation eligible, and there's a relatively small number that have this prohibition on it already. So it's just, again, this sort of random collection of stuff.
And to that extent, it really does fit with our mandate in terms of revising and rationalize the penal code. All right, I want to keep us moving. So with the motion to strike number 2 and 3, we're just voting on number 1, creating probation, allowing probation, all nonviolent crimes, all crimes that are not on the list of violent crimes in the penal code. Probation is a possible offense, not required, no presumption one way or another. I'd like to make this our third recommendation of the committee. Okay, without objection, we're going to adopt that as the third recommendation of the committee. Excellent. 4, this is the aggravated theft and Estes situation that we've discussed, where a relatively petty offense, such as shoplifting, which is a mandatory misdemeanor, elevates to a robbery, which is a violent crime, violent felony with a maximum sentence of 5 years. If there's any altercation with, for example, store security, that altercation can be verbal threats without anything more. The proposal is to create to establish a new crime between petty theft and between shoplifting, true shoplifting, where you're shoving the sandwich in your pocket and you slip out the door and don't tell anybody, and actual robbery, to create a middle tier that is not the violent 5-year robbery punishment that we're going to call aggravated theft, if that makes sense. So we're not eliminating the punishment, we're just reducing it from a 5-year sentence and everything that goes along with having a violent felony. To clarify, if the theft involved a weapon or serious injury, that would be robbery. We're talking about the truly brief encounters with the victim where there's no injury, no weapons. But this is not petty theft or shoplifting. This is now aggravated theft. It's not robbery either. It's the in-between. This is a very, very common street crime. Obviously, it's a crime of poverty and racially disproportionate. Here are the details and decisions. Establish an offense called new aggravated theft.
Go back a minute. Go back to the first.
Shit. Excuse my
Sorry.
language. That's all right.
It's okay. I know the details will give more, illustrate better, but so what we're trying to address is the last point. In effect, the impact is also the problem we're trying to address, correct?
Yes.
And maybe it's more detailed in the next set, but I think that we should be really clear. It shouldn't just be the estimated impact, it should be the problem statement. This is what we're trying to address, because it's going to be a matter of how the statute is written as to whether it does in fact this impact.
Okay, we can add that as our first detail. So.
Can I raise another issue?
Oh,
Yeah, sorry.
Sorry.
I moved on.
I'm sorry,
Yes, go
Dean.
ahead.
Go ahead, Dean.
okay. I'm just wanting to articulate something. I don't know if it matters or not, but it's bothering me. One of the things that as a committee we're noticing as a problem is over criminalization, the increasing number of statutes and crimes. So it sort of seems inconsistent to say we want another crime added to the books. And so I really want to think more about, is there a way to address it without recommending new crime. So I think Senator Skinner's point about at least saying why we're doing it is critically important. To use Senator Skinner's point of the unintended consequences, I would hate to say, add a new crime, and then 10 years from now, we have more people entering the criminal justice system because we did this. So I just wanted to articulate that because it's bothering me.
I agree completely, and I think that we should adopt Senator Skinner's suggestion that the intent of this is to lower the punishment. However, we did look into just amending the robbery statute, right? Rather than creating a new offense. Or amending the shoplifting.
Does that not work? Does that not work?
It does not work because robbery in other parts of the penal code makes it a violent crime, any robbery.
Right.
So
Makes it a strike.
It's a strike, any robbery. Even if we made the punishment 1 week in jail, it's a strike. It creates all sorts of credit consequences. It creates where you're supposed to, if you serve in jail or prison, it has a lot of ramifications. So we couldn't put in the robbery statute. We could put it in the shoplifting statute perhaps, but that was created by Prop 47 and we run into some potential. So I agree, to add to the number of crimes in the penal code is against
art, yeah.
But I think to create the middle tier, which is the objective, this is the best way to do it.
Well, it may add a new crime, but it really reduces exposure to punishment for a large swath of folks who are currently being charged with Estes robberies. And I just want to raise an issue that I raise every time we discuss this and see if there's some way to elevate it in the language of any of this recommendation. And that is that this Estes robbery practice is used to file robbery charges against people with serious mental illness who frequently do not have the decision-making capacity that the rest of us have when confronted by store security. So I don't know how we don't.
Well, I think
let me have a couple of reactions to that. Sorry, let me just answer quickly before. So absolutely the analysis, we're going to include the disparate impact on people with mental illness as a justification for this. Number two is we intend to adopt language that if it fits you cannot charge robbery. If it fits the elements of aggravated theft, you are prohibited from charging as robbery. That's the way the current shoplifting statute is. You cannot upcharge from this. So this would actually reduce the number of robbery charges by statute and reduce the maximum punishment of robbery from, which is currently 5 years in violent offense, to, if we make it a wobbler, which is decision number 2, a maximum punishment of 3 years. Which may be a modest.
Under wobbler, if it becomes a felony, is it then a strike? Because it's good to eliminate this as a strike entirely.
No, it is eliminated as a strike. As long as it's not called robbery, it's eliminated as a strike.
Okay.
That is a big point. That's why we can't just amend the robbery statute.
Why can't we just amend the shoplifting statute to cover some of these?
Because we thought about that, but it was created by Proposition 47, and we're running into a 2/3 problem.
You could conceivably redefine some of the words in the robbery statute. They use the word force or fear, and that's what allows these things to be treated as robberies. Essentially, any force will satisfy it without creating a new offense. But that would just leave the existing theft statutes there, and you wouldn't have this sort of third option that many people might feel is appropriate. And the other thing I would add is I think both CPDA and CACJ, the two sort of criminal defense organizations, have had bills asking for this for many years, I've discovered. So I think the concerns about overcriminalization are very resonant, but folks who I think would share those concerns in a serious way, I think would support this.
Okay, well, that's really,
Michael, you said
Also,
something that,
yeah,
you said something that this would preclude the prosecutor from filing a robbery charge and
if it
in one
fit
of
these circumstances.
situations?
If it fit
Yeah.
the if it fit the otherwise they'd always be charged as robbery.
Right.
So
Well, I
If
could
it
see a lot of
fit this crime.
situations where, it was ambiguous as to whether or not there was a weapon or whether or not there was serious injury. They're still going to file a robbery charge.
if they can allege with probable
Allege it.
cause that there was a weapon, then they're allowed to charge it as robbery. That's just
Well,
as ambiguous as any other type of crime or
Yeah.
situation.
Or serious injury.
Same goes there. They charge that all the time, and that's challenged in court. I'd like to say a couple other things. First of all, the law enforcement folks who testified on this all agreed that this is really not worthy of robbery. Number two is the robbery statute is over 150 years old. It's really antiquated.
So, okay,
Okay.
I think I think the points you just made, we're all in agreement. So that
Okay.
part, we're not, as they say, we're not quibbling. I think the issue is, as Dean Richardson pointed out, the creation of a new penal code crime. And so, of course, if this is the only way to achieve it, then yes. So, but perhaps what we do in our problem statement, so in the first slide, we put, this is the problem we're trying to address. Enact this if it addresses it, unless you have another, I mean, I'm being a little weird wording, but for example, the amending of the shoplifting statute, according to my own public safety staff who do these bill analysis, there are ways to amend it without touching the 2/3 vote. Now, whether they are adequate, I don't know. That I have to look at more. But there are ways. Whether they would address everything we have in mind, don't know. But then, for example, in this details, number 3, I would not make that explicit, only because this definition of weapon, we've had experience where like a homeless person with a stick that's then considered the weapon, and it throws into robbery, or say the mentally ill person. And so I'm not sure we want to be too explicit around exclude any theft with a weapon, because that interpretation of what is a weapon, unless we are explicit that it's exclude any theft with a firearm. But then becomes the other issue of, is it the firearm just on the person, or do they have to show the firearm?
Sure.
So
Right.
there's a lot of issues around that number 3.
Let's try to resolve some of that. So first of all, with the weapon issue, I think that we could use it as a deadly weapon. That's a very common term of art. And I think that, and that used with
It's a deadly weapon.
A bat.
that is, I think that if you rob somebody with a deadly weapon, that's more serious than Estes robberies. I mean, I do.
But it's the issue of if they use the weapon.
Yes,
You know what I mean?
used a deadly weapon. That
Right.
is, there's plenty of different, we would specify that it has to be used, not merely being armed. There's plenty of statutes that say armed with a weapon versus use a weapon. So it would be used to facilitate the crime, a deadly weapon.
Right, because that language isn't explicit.
Okay, we can, that's with an amended. And then you had another concern about can you amend the shoplifting statute, whatnot. We can look into that. I'm not so sure.
I mean, I know we can, okay? I know we can. Whether
Correct.
we can adequately is a different story.
Adequately. The other piece is that we're getting towards 5, and this is something that we hadn't quite discussed, is do we want to just address the shoplifting situation where there's altercation with store personnel, or do we want to expand this to all sort of petty theft situations, such as purse snatchings, where you have the same sort of problems, meaning a threat to take your purse, that creates a robbery. And that's why I changed it from we originally talked about this as aggravated shoplifting and just amending the shoplifting statute, which could be addressed by perhaps just amending the shoplifting statute. But if we wanted to make it broader to theft, So there's no dispute about whether or not this is a retail establishment or not, which are all included in the shoplifting statute. But just if you steal something from somebody without a deadly weapon and without injury, that's not robbery anymore. That's aggravated theft. So that's another reason to create a clean new statute with the reservation about creating new crimes. Okay, go ahead.
This is going to sound very strange. I will say that up front, and it might not be worth any discussion at all, but I just want to say it. Is there another term that we can use instead of aggravated theft? Because these sound to me, aggravated theft makes it sound, in my view, worse than what it might be. And the way it's titled will have an impact on that person's life after, when it shows up on their record. Like I'm just saying, it sounds, that I'm acknowledging we might not want to spend time on this. Maybe that's the way our
No, I think, no, we have to spend time on it if we want this to be recommended of the committee. So right now we have different levels of theft. There's petty theft, there's grand theft, and then there's robbery.
There's grand theft person also.
Grand theft person. So
could it be petty theft 1? Like I just don't know how the California code works, but there's something about the word aggravated that makes it sound really bad, and it's not right, in the way. I'm not saying crime is good. I don't want to be misunderstood.
Right. It could be first degree and second degree.
First degree petty theft.
Yeah, something like that. I like that way better than aggravated theft when you're looking at someone's, criminal history.
And move the other current petty theft to second degree petty theft.
However it is, if people are open to that, we don't have to spend much time on it, but
no, this is important. This is important.
So
how do people feel about?
I think I think wording
matters.
Okay. So the current amendments that we have on the table is, first, Senator Skinner's put the objective at the top, meaning that this is an objective to reduce the punishment of robbery in these types of situations. Amendment number 2 from Dean Richardson is that we're not calling this aggravated theft. We would be calling it first degree petty theft, and then amending the remaining petty theft to second degree. Okay. So that's the next. The punishment would be is proposed to be a wobbler.
Okay, so here comes the question of why does it need to be a wobbler? Why can't it be a misdemeanor?
Because then it's no different from petty theft or shoplifting.
Well, we've kind of already established that we didn't think these things, are that's serious.
Okay, so the question is it more serious? If they're equally serious, we can say this should always be shoplifting and this should always be petty theft. The question is a theft where you threaten or bump shoulders or everything short of injuring the victim more serious than the shoplifting situation where you stick a pack of batteries in your pocket and don't tell anybody, don't touch anybody, and leave the store?
So threaten, there's a big difference to me of threatened and bump shoulders. Bump shoulders can happen when I'm trying to run out of that store fast.
Well, right now that's a robbery. Now,
right. So yes, I know. I want to eliminate the bump shoulders. Threaten is something different, but then these are hard to define in statute.
Well, that's why they pay you the big bucks. We're not writing the statute. We're sort of picking
misdemeanors. Look, misdemeanors you can still serve
a year.
Is that okay? A year, okay.
But that it would be it would make no difference in punishment between a true shoplifting and one of these first degree shoplifting. In which case, I don't know why we would even create the first degree shoplifting if there's no, we could just prohibit robberies in those situations.
Yeah, that may be the way to go.
Tom?
I was going to say, I think the petty theft, or whatever the precise term is a 6-month misdemeanor. You could conceivably create a 12-month misdemeanor to come up to that 1-year limit that Justice Mourinho mentioned. Keep it a misdemeanor, have the possibility of increased punishment to distinguish the two things. That might work.
Like it way better.
Yes.
Okay.
Agreed.
Okay. So we're still having so we're still creating first degree theft, first degree petty theft, maximum punishment, 1-year county jail.
That's a pretty good punishment. I mean, again, it's a matter of, I mean, that's a whole year that you are removed from, yeah.
Yes and no. Because of prison policies, jail policies that currently exist, I'm just going to say.
Yeah, you don't serve as much time. It's true, but you still have that, well, whatever. It's.
I agree.
Just as long as we understand that wrinkle.
Right.
Yeah, and taking into account what we heard Judge Henderson talk about this morning, and the way that we're trying to change the culture of our criminal justice system, and the way we're trying to, I mean, 1 year is a lot, even if it might not be 1 year, right? So I agree with that.
And we also know, I mean, I wish that the level of sentence and the type of sentence was the deterrent, but all the data shows us it's not, because the person engaged in it doesn't understand, doesn't know these things. And so to add more time just because, you know what I'm trying to say. So I think the 1 year is.
I just have to say, I think it becomes increasingly challenging to try to come up with recommendations that are out of context when the end goal is to actually change prosecutorial behavior. And so, while they're not mutually exclusive, they are not the same thing. And so we're discussing creating an additional crime to add as an alternative to what prosecutors are already using, with the hope being that they will then see this as a viable alternative and use it instead of.
No, not a hope. This will be required.
Required.
That's the point.
Right. So, but the reason why I think there's so much discussion is, well, you're adding, you're not replacing.
But you're saying that if you fit this quality, you have to be charged this way. You cannot be charged.
And so then each of us, either in our head or on the screen, are sharing examples of how an end run can happen. So ultimately, you know, there is this sort of greater, almost existential discussion about, you know, how are we going to change prosecutorial behavior? So, I mean, I just have to put that out there because I'm engaged, and then at the same time I'm thinking, well, that's my goal, and is this going to get to that goal? And I just can't say that it will. So either I personally have to make a decision that that is not the outcome, and so what else can we do to on a macro level to shape that, and then be okay with adding a new crime, knowing that there's also data out there that shows in the past when legislature has done this, the reverse or adverse has happened. So I think that's the tension.
I totally agree. I understand. I will say that there was a lot of charging around, especially around realignment. And a lot of people suffered more about it. The net result, though, was a dramatic decrease. They're going to always be, not when you consider the 97% of all cases are resolved by plea agreement, there's always stuff on the table. They're always going to be able to charge things in different ways once you change the punishments in almost every single circumstance. This would absolutely reduce, for these circumstances, the maximum punishment from this crime from 5 years, violent felony, to a misdemeanor and a strike, to a misdemeanor, 1 year county jail. That's a significant reduction for a quite common crime.
Well, then we just have to work to elect more progressive prosecutors.
Well, I think this is, if passed, it's robbery and burglary are the two most common crimes in America by a lot. And we're proposing reducing the punishment by 80%.
Right. I think Assemblymember Kamalager-Dove's points were really good, because while I did not express this as what was in the back of my mind, it was this whole thing of how does the prosecutor treat it? And this is why I think that the things like using the word weapon, because again, there's those circumstances where a common, many of us carry a pocket knife. So things that commonly are on a person can then be used to elevate the charge in the circumstance. And so I'm much more comfortable with the direction we're going, which is the, a kind of enhanced petty theft. And I'm much more comfortable eliminating the concept of wobbler. But I think we still have to if we're going to have exclude theft with weapon, we have to say exclude theft with exclude it when a weapon is used.
Yes.
Versus just. And yeah.
I have the revised proposals here. Okay. The last item on this list is also difficult. Would we recommend that this be imposed retroactively?
Yes.
Yes.
Okay, maybe not so complicated. So
That was the easiest one.
just talk to the judges about that, but okay. So here we go. I have written down these as the current. Number one, start with the policy statement that Senator Skinner suggested. Number two, we're changing this to first degree petty theft. Number three, mandatory misdemeanor with maximum punishment of 1 year in county jail. Number four, excluded is use of a deadly weapon. Number five, excluded is if in the course resulted in serious bodily injury. Those are now remain robberies. Number five, retroactive. Any additional comments?
I'm sorry to interrupt again, Mike, but I think it's worth it because there was so much change for this. I think if you refresh, you'll see the changes that I've made, and it might be, prudent to do it while it's fresh in everyone's mind. But if it doesn't work, we can definitely come back to it. All right, didn't work. We'll figure it out. But there we go.
Okay, with these amendments.
And I sorry to interrupt again. I struck out number five because it seems like that is
Yes.
part of number one now, essentially. Just want to make sure. Okay, thank you.
Sorry. Okay. With these amendments, do people have final thoughts? This is a big one, guys. This is a
Huge.
very, very common crime, reducing it by 80% and making it a mandatory misdemeanor. It will reduce the prison population because there are a lot of people in robbery because it's a violent crime. You have to go to prison for a violent crime.
This directly addresses racial disparities based on homelessness, poverty, and mental illness. I just think this is good.
Great. All right. So I move to make this our,
I think the way we've worded it achieves this, but what we want to make sure is that petty theft, real petty theft, doesn't get elevated.
That becomes second, that remains the same. It just, the only change is that it becomes second degree petty theft.
Okay.
With that said, I'm moving to make this our fourth recommendation of the committee.
So in effect, we have to, it's not here, and I'm not going to worry about it right now, but we have to kind of have a definition or the criteria for what elevates the thing from the petty theft to this new first degree petty theft.
Yes.
That's right.
So we're not
Okay.
all of a sudden turning all petty thefts into 1 year versus,
No,
Exactly.
No.
Yes.
okay.
it's. Any objection? All right, this will become our fourth recommendation from the committee. Congratulations. All right. I'd like to try to get to our fifth one before we take a break. So we do 5 and then 5, okay? We're moving into the world of enhancements. This is Section 1385 currently allows judges to dismiss enhancements in furtherance of justice. There's no guidance, and the California Supreme Court has called this an amorphous concept. It's used infrequently and haphazardly throughout the system. This proposal would create presumptions that are overcomable, so not requirements, to strike enhancements under 1385. Recall that we're taking this approach because many of the enhancements that we've talked about as being especially problematic are protected by voter initiative. This is a way to ameliorate some of the harshest consequences of those initiatives, giving judges more authority without amending the initiative itself. So we create a series of situations where there would be presumed to exercise the authority to dismiss the enhancement. The full list is on the next page. But just to give an example, if the current offense is nonviolent, if it's based on a prior conviction that's more than 10 years old, if there are multiple enhancements alleged in a single case, those would be the type of situations, just so we understand the universe. Okay. Next page. Establish presumptions, but not requirements for judges to dismiss enhancements under 1385 in certain circumstances. These are the circumstances that we came up with. If the current offense is nonviolent, this addresses things like nonviolent 3 strikes, nonviolent gang enhancements, misdemeanor gang enhancements. This would give a presumption that those should be stricken. Now, the presumption can be overcome, but it's a presumption. If it's based on a prior conviction that's more than 5 years old, this is commonly called as a washout period in many states. If the offense is connected to mental illness, if the offense was committed as a juvenile, if there are multiple enhancements alleged for the same offense, or if the total offense would result in 20 or more year sentence. If the gun was not loaded or inoperable, this applies specifically to the gun enhancements. So right now, it doesn't matter if you used a totally inoperable gun. Or if there's evidence of disparate racial impact, and that borrows from the Racial Justice Act. If a judge finds evidence of disparate racial impact, again, the gang enhancements come immediately to mind. Then there would be a presumption to strike the charged enhancement. Before we get on to number 2, do people have concerns with any of the ones that we listed, or should others be added or subtracted, or problems with the presumption construct altogether? Yes, Justice Moreno. You're on mute. I can't hear you, Justice Moreno.
Sorry. I have an issue with respect to how the disparate racial impact would come before the judge. What would be the argument? I know we've heard testimony with respect to gang enhancements, 92% are people of color. But I mean, I'm just thinking, how would a judge receive evidence, and what kind of foundation would there be for him or he or she making a finding that in this
I
particular
agree.
case? Yeah,
I agree. That's very difficult.
It's too amorphous.
Tom, can you describe the Racial Justice Act, or maybe Senator Skinner to describe how they dealt with it in that context?
It's a bill that was just passed this year and was signed into law by the Gov. It leaves a lot of interpretation. It's got some specificity, but just as you pointed out, Judge Moreno, it is one of those things where how do you really define it? So it leaves a lot to courts to subjectively figure out. I have a suggestion. I'm not addressing per se what Judge Moreno just raised, because I think it's legit. I don't know how to define it, but I think we might add an additional circumstance, which is kind of a catch-all, but we could add a dash if the judge finds an additionally compelling reason.
Yeah.
Well, the current standard is the interests of justice. So,
well, we are now giving certain things we think are compelling that could be considered in the interest of justice.
I like that. I get that. I like that. So we're just saying that this is not exclusive. We're making very clear that it's not an exclusive list.
Correct.
Right. That would be good. I mean, it could be a social economic circumstance, or the circumstances of his life, et cetera, would cover that without specifying any of these things. I like that.
Other thoughts or concerns? What do people think about the lack of clarity and disparate racial impact?
I'm fine with that, because I think unless Judge Moreno and Judge Espinoza disagree, it seems like each judge in the exercise of their discretion could determine for herself or himself what evidence is sufficient to trigger that provision.
Yeah.
I don't know.
So I've been in enough spaces in the last 5 years to have a pretty clear understanding of what racial equity means in terms of criminal justice, because I've been engaged in a lot of conversations, but I think the average judge who sees this isn't going to know exactly what to do with it.
I agree with that.
I'm not, by the way, I'm not arguing for removing it. I'm just saying, I don't know. There needs to be room for a judge to consider all factors in mitigation, including childhood trauma, prior victimization of the person accused of the current crime. All of those things should come into play when a judge is making any decision regarding sentencing, but particularly in the context of dismissing enhancements. But I don't know what a judge will do in an individual case.
The problem that we're trying to address is that the current standard, which is wide open, nobody addresses those particular concerns. So we're trying to focus the judge's attention and saying that the legislature thinks that these are specific circumstances. I would add to the list prior victimization or childhood trauma as additional bullet points, along with additional compelling circumstances. I guess
the prior victimization, I think, is an important one to add, and we can combine them only because when I think about, for example, some of the circumstances that I'm sent that are reviewing, say, some of the women's convictions where they get a gang enhancement, but their involvement in the gang was due to the victimization. So but so there was no choice. In effect, they had no choice but to be involved in the gang, and yet they then got additional years. So I think that additional victimization specific is a good one.
I agree. To try to focus our conversation though, before it gets lost, I think this disparate racial impact, Judge Moreno, are you okay with leaving it vague? Is everybody else with leaving it vague, or do we want to
Well,
strike it?
So
Can we just
have
focus on that piece before we move on to others? Yeah.
So obviously I talk about race and equity a lot, and I somewhat have a problem with this because, you know, we just went through an election in November. Prop 16 was on the ballot. It was all about sort of race, equity, and disparity. And there were so many ways to argue it. So it just is, this is incredibly subjective. It is different if you're in Riverside than if you're in YOLO, than if you're in San Francisco. And there are just so many ways to really kind of weaponize this issue. So I don't know, without so many guardrails, how it actually helps, or if in effect you end up opening up a Pandora's box. I am far more comfortable with figuring out ways to include sort of past histories and circumstances, because I think that plays a huge role. And oftentimes it is left out of the conversations when either talking about pleas or when charges are being discussed. You know, people look at what you've done as if in that moment is determining, you know, the scope of your past and your future, rather than really being honest about the things that happened in your past that might have predicated why you ended up in this particular circumstance or why you committed a crime. So I'm actually much more comfortable with that than this, because, you know, Ward Connolly, for example, and I are both Black, and I think we have very different opinions on what race means. So
Can I jump in for a second? Because I think Assemblymember Kamlager, Dove, what a great point. I completely understand where you're coming from. And I want to add the opposite point of view now as a former public defender. What I like about it, even though it could go in exactly the direction that you mentioned, Assemblymember. So the opposite argument is, what I like about having it in there is when I'm representing someone and asking the judge to dismiss the enhancement, I like being able to point to something that gives her the ability to do that. And then I can make the argument about why this enhancement has a disparate racial impact, versus if it's not there at all, then the worry would be, I want to make that argument, and the judge comes back to me and says, yes, counsel, but even though this is a broad, even though there are certain things listed and it's not limited to that list, it's more powerful to be able to point to it. And I make the argument, however I want to make it, that there is a disparate impact here.
Justice Moreno?
Well, I guess it's just the term, you know, racial impact that I think everything else might be subsumed in that, you know, circumstance, socioeconomic circumstances, where the defendant grew up, the lack of education, etc. Other gangs, thinking about the gang enhancement, his parents were gang members, etc. Without reference to the racial term, because I agree with Kamala that it's going to be kind of a hot button issue. And I think in practicality, judges will take it into account without having it specified in a presumption.
I think the other thing, just to also add to this, is that oftentimes what you do here is, you know, the victim and the perpetrator are of the same race.
Right.
You know, I mean, so I'm in agreement with, I am just playing devil's advocate, and I'm just trying to be really honest about what happens in the courtroom.
No,
if I may. I'm a little bit not concerned. I'm less concerned about the potential negative consequences, Assembly Member, because we're only talking about reducing sentences, right? There's no way that this could increase somebody's sentence. Second, I agree with Dean Richardson that race is the elephant in the room in criminal justice. And as practitioners, we are so rarely allowed to talk about it. It's just, that's not relevant. And I agree also with what Senator Skinner said with the Racial Justice Act. It's going to be a mess, but at least for the first time ever, there'll be public defenders and defense attorneys standing up and saying, my client is getting a worse sentence because he is Black, period. And even if the judge says, I don't agree, I've looked at the evidence and no, they've done something horrible, but you are not allowed to say that right now. And this opens the door to at least be able to say that. And I think that that's a positive step, even if it is vague, and I'm less concerned. And I should say, with all of our proposals, there are potential negative unintended consequences. And part of the reason why we want to be so aggressive about the data is to make sure that those don't happen and that we come back next year and say, like, we made a mistake. The robbery statute should have not been amended the way that we meant it to. So I think for the legislature to take a stand to say that if a judge again, it's vague and it leaves a lot of room to interpretation, but for the California legislature to say that if a judge thinks that there's disparate racial impact in this case, they should strike the strike.
I must be hanging around with the wrong lawyers then, who go to the wrong courtrooms, because I know a bunch of people who talk about race.
Yeah.
I've been scolded.
Me too. That's why I like it. I like to be able to point to it. And I think to Justice Moreno's point, I think I agree with you. There are so many things that can have a disparate impact, not limited to race. But in this country, I would say that race is in its own category. So I would not take race out. I would leave it in there. And then other things can be argued in general, as they always are, but race is such a hot button issue that I agree with what Mike was saying, right? Like, no one wants to deal with it, and judges stop you from talking about it. So I think it's really important to include something explicit like that.
Okay, well, I do really want to have consensus on all. It seems like this is the only one that there's any concern about. Are there other, before we resolve where we stand on this, are there other, with the adding the catch-all of compelling circumstances and prior victimization and childhood trauma on the race thing, I would really like to come to consensus about whether or not we strike it, include it, or somehow reword it in a way that feels better.
So this is Espinosa. I think we keep it.
Yeah.
Because it makes a statement about what we know to be true, that there are racial disparities in filings and prosecutions.
Exactly. Yeah.
I continue to have a concern about a judge looking at this and not knowing what to do with it, but I don't think it hurts to have it there.
It doesn't require, the good news on that is it doesn't require a judge to do anything. So if a judge throws up their hands and say, I don't get it and I don't see it, then that's fine.
But we've given them plenty of other, particularly with the inclusion of prior victimization and childhood trauma, we've given judges plenty of tools to strike enhancements.
So are we all okay with the disparate racial impact?
Yes.
Okay.
Yes.
Great. I think this is, I think I agree with the problems, but I think it's just a very good statements for the committee and for the legislature in general. Point 2, and this is the last before break.
Sorry, Mike, can I raise one point on the catch-all? I think specifying that this isn't exclusive, like, you can still strike or in other circumstances, but I wonder how having a presumption based on the catch-all would kind of work in practice. We could talk about this later in the analysis later, but saying it's a presumption you'll strike if there's compelling circumstances. I don't know if we want to talk about that a little bit more.
No, they have to strike if there are other compelling circumstances. We'll smooth that out to make sure that there's a catch. The purpose is that I think
Catch-all,
Senator
okay.
Skinner, that we don't want to make sure that this is not an exclusive list, and that failure to fall on this list does not mean that you're not, right?
Well, so I
Gotcha.
guess to that point, if these are the circumstances and then race is considered a circumstance, then when the judge is making their statement, then they should be allowed or forced to declare that, right? Upon consideration of race, upon consideration of trauma,
Yep.
upon consideration that this current offense is nonviolent, right? So then that maybe should also be in part of the crafting, because you're not putting it in, I don't want to put something on here just for symbolism.
No, it's part of the statute already requires the judge to put their reasons in the record.
Okay.
So moving to point 2, which I think is complicated. So to create a presumption is one thing, to say it's presumed to be stricken, but that's a little bit hard without saying how the presumption should be overcome, right? So the question is, do we create language to tell a judge when the presumption could be overcome? So let's put the race question and some of the ambiguous ones aside. Well, let's say the prior conviction was more than 5 years old, black and white. Okay, there's no doubt about that. That means the presumption applies. How can the presumption be overcome? And the proposal is that the presumption can be overcome if the judge finds in writing clear and convincing evidence that dismissal of the enhancement would endanger public safety. That's the only way to overcome these presumptions.
It's hard for me to, I would like to hear the judge's response, because it's hard for me to understand how that would actually work in practice. So I look forward to Dean Richardson and just you three, if you have any comments on this one.
Yeah.
So in my view, the way that it would work in practice is the prosecutor would come armed at the time of sentencing with a list of factors, reasons, facts that would urge the judge to find that striking this enhancement would endanger public safety. I don't know what those factors would be. I've never been a prosecutor, but I've certainly listened to lots of arguments. It may, I don't know. But that's how it would work.
So is that an argument for not to be silent on 2?
No, not really. I was just a response to what it might look like in practice.
And I want to follow up on that, Judge Espinoza, because that's exactly what I was thinking about. And it led me, Senator Skinner, to think we should be silent on 2. But I don't know if that's just my initial response, having seen too many times that having language like that's vague, right? Clear and convincing is vague, and prosecutors can come up with all sorts of things that they would argue endanger public safety, and putting an elected judge then in this position to have to dismiss what the prosecutor says in order to dismiss the enhancement in a more difficult position. That's what it seems like to me, but I'm not a judge. So I'd love to hear what you have to say too, Judge Moreno, Justice Moreno.
I'm still thinking about it. At first I thought clear and convincing was kind of a very, vigorous standard, but I'm not sure. Let me give it some more thought.
While you're thinking, here's my concern, is if you don't give it a standard, then judge is sort of left with, well, I'm supposed to presume, but okay, I presume that, but I'm overcoming it without any standard whatsoever. And they're gonna, DAs are already coming in and will certainly come in with the parade of horribles, regardless of what, and their horribles are always the same, that it's endangering public safety. So it's not like we're creating a roadmap on how to overcome them. The road is well worn.
Yeah.
So Mike, are we do we need, I mean, since these are not requirements, they're only presumptions, why do we need to? Because the judge still has this.
Because you could
If
say,
we
for
were
example,
making these presumptions requirements, then it seems to me you need something like 2, because you have to give them a safety valve. But since we're not making them requirements, I don't think we need it.